Marie Sparks, BD and Marketing Manager at Keaton Chambers, and I'd like to introduce today's speakers, Sean Wilken QC, Rachael and John McMillan. Over the next 40 minutes, Sean, Rachael and John will look at the pitfalls in international arbitration from a counsel perspective, with a focus on construction and energy projects. This will be followed by a live Q&A with the panel. They'll be responding to questions received in advance of the webinar, as well as those posed during. If you'd like to submit a question, please use the box on the right-hand side of your screen. I'll hand you over to Sean.
Good morning, and thanks for attending. So we're going to do, as Marie said, a series of 6 little talks, and then there'll be a Q&A afterwards. I'm going to start talking about the question of seat and whether, to start with, you have a choice at all. Because it often can be that you don't, where, for example, you have an energy contract, you may well have the seat stipulated by the host nation or the national captive company. They will have policies and they will want arbitration in particular places. It may also, again, in the energy context, follow the agreement with the host nation. So where you have a PSC, production sharing contract, or PSA, production sharing agreement, that will have its own arbitration provisions, and therefore those may well take any subsidiary contract, such as a farm in or a farm out, or a joint operating agreement with them. You may also have an issue with the local content laws. So there are various nations around the world who wish to boost their internal knowledge and expertise, and also don't want to farm out all the subsidiary activities around energy projects to international. So they have local content laws. So in Nigeria, for example, even if you have what would otherwise be an international arbitration between international parties, there is local content law which brings everything onshore, and they are treated as domestic arbitrations. Then you might also have the issue decided by other advisors. Very often, obviously, the suite of contracts is drafted by another firm or indeed by a government department, and they're the ones who put the clause in. Then, of course, finally, the usual reason why people don't have a choice is they didn't actually focus on reading the DRP during the currency of the project. Can I have the next slide, please? And I will then move on to this, what happens if you do have a choice. Things you've got to take into account. Geopolitical realities. One can go back to the Cold War when Stockholm and Helsinki were very popular, and Geneva for arbitrations, because of course they were neutral territory. In the modern age, questions to ask: who are the likely parties to the arbitration and who controls them? What are the controlling entities? Are there any political issues around enforcement? Here we have the example of Russia. Their survey of enforcement 2009 to 2017 showed that overall pretty good strike rate of 80 to 97%, but for the ICC the rate was 61%, and for the LCIA it was 47%, and fell to 34% in disputes over Euro 10 million. And unsurprisingly, in the present climate, very low rate indeed for any disputes relating to the Ukraine. Next issue to consider: neutrality versus home player advantage. Do you want a neutral venue? So India and China, people very often choose Singapore these days. Or do you want a home player advantage? So do you want, if you're acting for a Chinese entity, the arbitration to be in CTAC or in the HKIAC? Finally, your compliance issues. Does the existence of a sanctions regime affect you? What is the state like in terms of corruption? Are you likely to have OFAC on your case because you've got a potential US sanctions breach? And of course, in terms of the UK, you have the Bribery Act. If we can have the next slide for some more considerations. Think about wrinkles in the applicable law. Confidentiality. In the Anglo-Saxon jurisdictions, by and large, confidentiality is followed, though the basis for that in law still remains unclear. Other jurisdictions don't have confidentiality, and if that is important, that is worth thinking about. Is the underlying instrument enforceable at all? This is quite important because certain forms of financial security, and I'm thinking in particular on-demand letters of credit and unlimited letters of credit with no expiry date, might not be enforceable in the UAE, Japan, and surprisingly, certain US jurisdictions. And then are there any oddities about where hearings have to be held? E.g., if you are in the DIAC, where all hearings have to be in Dubai, you obviously have to take that into account. That will obviously raise at present current issues about COVID, which I'll come on to discuss next in the next slide. Practical considerations. Obviously at present, we have a position where it is difficult, you're going to be hearing everything remotely. But it is going to be a fact of life, COVID, for the foreseeable future. And we already have a question about this, which we will handle at the end. Are we going to have nations which group into COVID bubbles? In other words, where you can move freely between a couple of nations, and Australia and New Zealand are already discussing it, but not elsewhere. Is this something you're going to have to take into account? Is your arbitrator willing to sit in that jurisdiction? This is important because the UAE in recent history, passed an act which enabled arbitrators against whom allegations of bias were made to have their passports taken when they entered the UAE. This obviously raised lots of questions for busy international arbitrators who rely on moving from jurisdiction to jurisdiction freely. Similarly, if you're not using an international arbitrator, what is the expertise of the local arbitral institutions and arbitrators like? Is your arbitrator, so does it have an acquired pool of expertise which you can draw on without too much difficulty? Security. Are you going to be able, at reasonable costs, to keep your team and the arbitral team safe? This is more of an issue in some countries than others. So are you going to have to think about things like K&R policies? Are you going to have to think about close protection? All these sort of issues do come to the fore, particularly where you have countries with an aggressive local content law, where you might end up not wishing to be there at all. That links to cost. Some jurisdictions are cheaper than others, some have nicer hotels. What are the costs of being in that particular venue? Finally, immigration. Can your arbitrator and witnesses get into the country? This is not a theoretical issue. During the hostile environment, I had one commercial court case and 2 arbitrations where I could not get clients and witnesses into the UK because they simply couldn't get visas. And that makes your running of your arbitration or your court case very, very difficult. So those are the practical considerations on seat. I will now hand over to John, who's going to deal with multi-contract disputes.
Morning all. As Sean said, I'm dealing with multi-contract issues in arbitration. If you practice in the construction and energy sectors, we see multi-contract situations every day. A construction project will be split between contracts between the employer, the contractor, subcontractors and so on. In an energy project, there may be a production sharing contract, a JOA and contracts with suppliers. Arbitration is good at dealing with single contract situations. It's less good at dealing with multi-contract situations. If the parties to dispute are not all signed up to a single arbitration agreement, it may be impossible to have a single proceeding to resolve all disputes absent the agreement of the parties. This can come as an unpleasant surprise. The only thing worse than one arbitration is, of course, 2 arbitrations. It drives up costs, it makes additional demands on staff time. Perhaps most seriously, it gives rise to the risk of inconsistent decisions. The only thing worse than 3 arbitrators getting it wrong is 6 arbitrators getting it wrong in different ways. If we can move on to the next slide, please. Luckily, arbitration has developed some mechanisms whereby multiple proceedings can be consolidated into a single proceeding, or disputes arising under more than one contract can be brought pursuant to a single arbitration agreement. The issue I'll be looking at today is where there are multiple arbitration agreements, but the parties don't agree to a single proceeding. That may sound like a niche issue, but in my experience, it comes up all the time. If you find yourself in that situation, the first port of call will be the arbitration statute at the seat of the arbitration. If you're in England and Wales, the Arbitration Act isn't much help, as Section 35 permits the consolidation of proceedings where the parties agree, but not otherwise. If we could move to the next slide, please. Other arbitration statutes are more favourable. I've given the example of the Dutch Code of Civil Procedure there. If you ever find yourself attempting to consolidate proceedings taking place within the Netherlands, that power is given to the Provisional Relief Judge of the District Court of Amsterdam. And perhaps more relevantly, the Hong Kong Arbitration Statute contains a wide power of consolidation given to the court, but less helpfully, it's an opt-in provision. And in general, you can't expect international parties to opt in to specific provisions in an international arbitration statute. If, as is often the case, the national arbitration statute isn't going to help, the next place to look are the applicable procedural rules in the arbitration. Most modern institutional rules contain a power to consolidate multiple proceedings in certain circumstances. And on the slide there, I've given the example of the ICC rules, which are typical. They provide that where claims are brought pursuant to more than one arbitration agreement, it's possible to consolidate if the parties agree, or if the parties are the same in each dispute, the disputes arise from the same legal relationship, and the arbitration agreements are compatible. If we can move to the next slide, please. Other institutional rules go quite a bit further. The HKIEC rules permit the consolidation of proceedings even where the parties are different, so long as the multiple proceedings all take place pursuant to the HKIEC rules, they raise common issues and they form part of a series of transactions. So in principle, at least, under the HKIEC rules, you could consolidate proceedings between an employer and a contractor and a subcontractor into a single proceeding. The HKIEC rules, the HKIEC is indeed very proud of the breadth of its power of consolidation and boasts on its website that it once consolidated 50 contract disputes, which could have been a wonderful thing to do or could have resulted in a completely crazy proceeding. It's a bit hard to say. The limitation with all these procedural rules is they only allow consolidation of proceedings taking place under their own rules. They don't deal with a situation where you have conflicting arbitration agreements. Where that is the case, and the arbitration agreements provide for different rules, you are first in trouble. You may find a solution under the law applicable to the arbitration agreement. Under English law, where a transaction is split into multiple contracts with conflicting arbitration agreements, it is sometimes possible to bring a dispute pursuant to the arbitration agreement at the centre of gravity of the dispute. I've given the example on the slide there of C and D1, which is perhaps the high point of English law reasoning on the topic. I'll simplify slightly, but the parties entered into a production sharing contract relating to mining leases, and then when joint operations had concluded, they entered into a share purchase agreement. The two contracts had conflicting arbitration agreements. The court held that a tribunal had jurisdiction to hear disputes arising under both the production sharing contract and the share purchase agreement, pursuant to the arbitration clause in the share purchase agreement. It was held that that arbitration clause was at the centre of the dispute, and it was broad enough to encompass claims arising under both contracts. I should say again, though, that if you find yourself arguing about where between two contracts the centre of the dispute lies, you're in a bad position. It's a highly fact-sensitive issue, and the consequences if you're wrong are very serious. If you have jurisdictional issues during the dispute, you need to argue about them before an arbitral institution, before the tribunal itself, often before the courts of the seat and any other courts where you wish to enforce your award. And you don't need to be right once, you need to be right every time to have an enforceable award at the end of the day. Other legal regimes are less restrictive than the English, and I've given the example of India on the slide. If we can move on to the next slide, please. Where it's not possible to arrange for a single proceeding to resolve all your disputes, you may still guard against the risk of inconsistent decisions by, for example, attempting to appoint the same tribunal member in each of the ongoing arbitrations. With somewhat more difficulty, you might even be able to persuade an arbitral institution or a state court to appoint the same presiding arbitrator in each of your arbitrations, though in my experience, an arbitral tribunal might be unwilling to do that in the face of a spirited objection from one of the parties. Move to the last slide, please. And I want to end just with some practical guidance. As with most contractual issues, if you anticipate you might end up in a multi-contract dispute, it's best to try and deal with this when the contracts are being negotiated. Is it possible to incorporate a single arbitration agreement into all your contracts? Can you include an express consolidation clause? And is arbitration the best route at all? Might you be better with a state court and its greater powers of case management? After a dispute arises, you should try and consider your options as early as possible. It's difficult to consolidate proceedings at the best of times. It's much harder to do so once different tribunals have been constituted under different contracts. And finally, with anything that might touch upon the jurisdiction of a tribunal, I would suggest that caution is king. It's much better to have multiple messy arbitrations than to have a single proceeding that goes all the way to an award, only to have that award annulled by a state court for lack of jurisdiction. I'm now going to pass on to Rachael.
Good morning. I'm going to begin by talking about dispute escalation clauses. Increasingly, we are seeing the use of dispute escalation clauses in large construction, infrastructure and energy disputes. This is particularly the case where parties opt for final determination of disputes by arbitration. However, during the current times of remote working and virtual hearings, we may in fact see more parties turning to alternative commercial dispute resolution for the final resolution of their disputes. No doubt many of you will be familiar with dispute escalation clauses. In the next 5 minutes or so, I will recap on some of the basics which may assist where you have an international arbitration governed by English law. So, by way of recap, dispute escalation clauses, what are they? Well, they contain stepped or waterfall procedures, and they provide for one or more forms of ADR or other steps prior to final determination of a dispute. Each step in the waterfall is designed to handle a dispute if it has not been resolved by the previous step in the process. Typical dispute escalation clauses may include a combination of steps. So, for example, to begin with, they may include informal stages, and these may include informal discussions, for example, between on-site senior personnel, which must take place within a specified period of time, or structured negotiations, which may take place between senior executives of a company, so for example, the CEOs or finance officers. And again, often these are required to take place within a specified period of time. And also, as part of the informal stage, there may be a requirement for a mediation under prescribed rules. Secondly, in the process, there may then be a more formal stage, and this may include, for example, an early neutral evaluation, an expert determination, or perhaps a contractual adjudication. And then finally, the last stage in the waterfall procedure will be a resolution of the dispute by way of arbitration. Now, when I was discussing this topic in the pre-COVID world, I asked an audience for their view on what they thought of these clauses. And there was an overwhelming consensus in the room that people found that these clauses actually had a positive effect on the resolution of disputes in an efficient manner. So what are the perceived pros and cons of these clauses? So first of all, I'll look at why are they useful. Well, first and foremost, they contain a pre-agreed mechanism for resolving disputes, and this can inevitably save costs and time, enabling the parties to focus on resolving the actual dispute. Sometimes parties will also unnecessarily pause before proposing, for example, a mediation or engagement with ADR. The benefit of these clauses are that there is no loss of face if a party proposes the use of ADR or a mediation at an early stage. They are also a great tool for resolving disputes during the contract works, meaning that the parties can focus on the important job of finishing the project and getting the job done rather than dealing with disputes. The ADR processes adopted by the parties can also be tailored to meet their specific needs. And so, for example, they can maintain confidentiality and help the parties to maintain a healthy commercial ongoing relationship. So what are some of the perceived disadvantages of these clauses? Well, if drafted poorly, they can lead to confusion about the steps that a party must take in order to resolve a dispute. And inevitably, this may result in satellite litigation. The processes can also become laborious and cumbersome. However, bear in mind that parties could choose to waive one or more of the steps in the process if they chose to do so. Going through the waterfall processes may also lead to further entrenchment of the parties' positions. Unfortunately, you may also find that some parties only pay lip service to the steps without truly engaging in them in the spirit of resolving the disputes. Also, obviously, if the processes take longer and more time, unfortunately, this may result in additional costs being spent in the process. Lastly, and importantly, consideration needs to be given as to whether or not your clause is enforceable. I'll come on to that in just a moment. So turning now to the question of whether or not the clause is enforceable. The requirements for an enforceable dispute escalation clause were reviewed and considered recently in the case of Open Operations against Invesco. In that case, Mrs. Justice O'Farrell reviewed the cases and gave helpful guidance on the applicable principles. She held that an agreement must create an enforceable obligation requiring the parties to engage in alternative dispute resolution. The obligation must be expressed clearly as a condition precedent to court proceedings or arbitration. The dispute resolution process to be followed does not have to be formal, but must be sufficiently clear and certain by reference to objective criteria, including machinery to appoint a mediator or determine any other necessary step in the proceedings, without the requirement for any further agreement by the parties. The court has a discretion to stay proceedings commenced in breach of an enforceable dispute resolution agreement. In exercising its discretion, the court will have regard to the public policy interest in assisting the parties to resolve their disputes. The judge then went on to say that there is a clear and strong policy in favour of enforcing alternative dispute resolution provisions and encouraging parties to attempt to resolve disputes prior to litigation. Where a contract contains valid machinery for resolving potential disputes between the parties, it will usually be necessary for the parties to allow that machinery, and the court will not permit an action to be brought in breach of such an agreement. For another case which considers the enforceability of such provisions, you may also wish to consider the slightly older case of Emirates Trading Agency against Prime Minerals. And there the court held that a dispute resolution clause which required the parties to seek to resolve a dispute by friendly discussions in good faith and within a limited period of time before the dispute could be referred to arbitration was indeed enforceable. So, pausing there for a moment, if your contract contains a dispute escalation clause, check the latest guidance to see whether or not it is enforceable. Moving on now to consider the question of whether or not certain steps in the waterfall will become finally binding if no further action is taken to challenge the outcome of that step. Often we will see that certain steps in a waterfall procedure, so for example, contractual adjudication, will become binding unless they are challenged within a specified time limit. In many instances, these time limits are short. So, for example, they may be 28 days or less. Therefore, there is not much time to consider whether or not you are going to challenge the outcome of that step. You need to make sure that any challenges are brought within the specified time limits, because otherwise you may lose your opportunity to challenge the decision in arbitration. Also, care needs to be given as to the scope of the dispute which is referred to each step. Otherwise, a party may find itself in a position where it has not in fact referred the same dispute through the earlier stages of the process. The result of this may be that a party may find itself in a position where the tribunal does not have jurisdiction in respect of the dispute which has been referred to it. And this is because it has not, in fact, been through the earlier stages of the dispute escalation clause procedure. So where the completion of the earlier steps are condition precedents, a party will have to go back and complete the earlier step of the procedure before being able to move on. So, a practical tip: make sure everyone who is dealing with the dispute resolution procedures are familiar with how the clause works. This may also include, for example, your project directors, if they are named in the earlier parts of the process. Beware that a failure to comply with the steps may result in a stay of proceedings pending completion of any of the earlier mandatory steps. I'm now going to hand you over to John. Thank you very much.
Thanks, Rachel. My second topic today is going to be hearings and cross-examination. When parties agree to arbitration, they're agreeing to a process which hands to arbitrators significant discretion as to how to organise their proceedings, without there being any real consensus about how proceedings are best organised. In other words, you don't always know what you're getting. In cases where counsel and the tribunal come from a similar background, this isn't a great issue. Parties come in with similar expectations. Where counsel and the tribunal come from different backgrounds, it can be more of an issue, and people can encounter procedural decisions that are unfamiliar or that they just think are plain wrong. One area where cultural expectations differ significantly is cross-examination, and wider than that, the organisation of oral hearings in general. Oral hearings and the questioning of witnesses are close to universally accepted, but that masks some differences, and I have a few examples of what I mean. The first is a survey that you can see on the slide there. It's a 2012 survey by Queen Mary University and Wilken QC, and it found that 31% of civil lawyers said the average duration of the hearings was 1 to 2 days, compared with 9% of common lawyers, whereas 34% of common lawyers said the average duration of their hearings was 6 to 10 days, compared to 12% of civil lawyers. Now, surveys aren't perfect, but I would suggest that that statistic exhibits some fairly sharp differences in how parties think hearings should be organised and in how parties think evidence should be assessed. What I'm going to caricature as the common law approach is that cross-examination is the main means to air and resolve factual disputes. That means that lawyers are given time to go through their cases with witnesses, and perhaps just as importantly, they have a duty to put to the points to witnesses but they later wish to contradict that witness in their submissions. What I'll caricature as the civil law approach is that factual disputes are more fully aired in memorials and to a larger extent decided on the documents. There's little or no duty to put points to witnesses where you wish to later contradict them, and the importance of oral evidence is in general de-emphasised. To make this somewhat more concrete, I was speaking to a civil law colleague recently, and they had recently handled an engineering dispute that was worth several $100 million. They got through 24 experts, 8 fact witnesses in 8 days. And now if we can move to the next slide, please. I've made the dichotomy a common law versus civil law, but I also think there's a difference between the approach taken by those who have a background in courtroom litigation and those who practice primarily or exclusively in arbitration. And I've found some quotations which I think exhibit the difference that I mean. The first quotation comes from Wilken QC, who's an English silk. And he says that proper cross-examination can take days or even weeks. And he says that modern arbitration has therefore moved away from the civil law position towards the common law position. If we can move to the next slide. Peter Lever's position might be contrasted with the position of David Rivkin, who's an American arbitrator. He says that virtually every case can be tried in 2 weeks or less, and he received almost universal agreement on that when he put it at an LCIA event. And it's immediately obvious that David Rivkin's 2-week hearings leave little room for Peter Lever's fortnight-long cross-examinations. The next slide shows the position of David Williams QC, who's a big name arbitrator now, but who used to be a New Zealand judge. And he again puts the point that cross-examination and arbitration is close to the common law tradition. And he puts the orthodox English position then that if you wish to contradict a witness, you have a duty to put points to that witness in cross-examination. If we could move to the next slide, please. And again, that might be contrasted with the position of Bernardo Cremades. He's a Spanish arbitrator. He supports the questioning of witnesses in arbitration, but he thinks that the same procedural rules just don't apply to the questioning of witnesses in arbitration. He particularly objects to what he calls cross-examinations emotive appeal to common lawyers. These are all big name arbitrators. And what's interesting to me is not just that they disagree, which you might expect, but they all root their views in some kind of orthodoxy or an emerging consensus, which I just don't think exists. In other words, they don't just think they're right, they think everyone else agrees with them too. I think two things flow from the disparity of views on how hearings should be organised and what the value of cross-examination is. First, you should be aware when picking a tribunal and making procedural applications that these different approaches exist and they're supported by reasonable people. For around half of all parties, longer hearings and more cross-examination doesn't help their case. In an age when we're increasingly talking about remote hearings, if you're trying to persuade a tribunal that a merits hearing can go ahead remotely, your position might be better served if you say that anything can be tried in 2 weeks than if you tell a tribunal they're going to need to sit through a 10-week-long webinar. Second, you should recognise and adapt to the procedures that are selected by the tribunal. You should not, as I have seen one prominent English QC do, loudly declare that the procedure being followed by the tribunal simply isn't cricket. The message being that sometimes in arbitration, as in life, it's possible to be too English about the whole thing. I'm now going to hand over to Sean.
Hello, we're handing you over to Rachel actually. So anyway, lovely to see you all again, back again. Going to have a quick chat to you now about expert evidence in international arbitration. Now, expert evidence is an important feature dealing with construction disputes. Often the cases that we are involved with concern complex technical, delay and quantum issues, and often cases will turn on the expert evidence. Expert evidence is expensive. Parties spend huge amounts of money preparing expert reports. However, often comparatively little thought is given to the presentation of the oral expert evidence until rather late in the day. Now, today I would like to touch briefly on oral expert evidence in arbitration hearings and share some of my thoughts about what might work in certain types of cases. I'm going to discuss firstly expert presentations and secondly witness conferencing. So firstly, turning to expert presentations. Most of the arbitral rules afford a certain flexibility in determining the procedure for the taking of evidence at the hearing, including oral testimony. Also, such flexible arrangements on the taking of oral evidence are envisaged under, for example, Articles 2 and 8 of the IBA rules on the taking of evidence. Therefore, tribunals may ask experts to produce a short oral expert presentation at the final hearing. For those of you who are not familiar with the use of these presentations, generally the presentations tend to involve experts of the same discipline providing a presentation of about, say, 10 minutes after the experts have been sworn in, but before they are cross-examined. Experts may choose to produce a PowerPoint or a handout for the purposes of the presentation. And the contents of the presentation are generally limited to that which is in an expert's report or in the expert joint statement. The bottom line being that the presentation should not be a vehicle by which the expert can introduce new material during the evidentiary hearing. but rather it's a roadmap to the evidence that they have already provided in their reports. Now, the last time I delivered this seminar again to an audience, the general response was that people who had experienced this process had had a generally positive experience with these presentations. And again, that certainly is also my personal experience. So turning to some of the pros of using these oral expert presentations. So firstly, these presentations can hugely assist the tribunal in understanding the expert's issues. Often the more traditional common law style of cross-examination will only provide the tribunal with snapshots from each side of a case, and may in some cases leave gaps in the tribunal's knowledge and understanding of the expert issues. The presentations provide the tribunal with an inroad into the expert evidence and almost a guided tour of the expert's views. They can also provide the tribunal with an opportunity to ask questions of the expert before there is detailed cross-examination. However, what are some of the potential cons of this process? If you have any concerns about how your expert may present during an open session, you may wish to avoid this type of informal presentation at the beginning of their evidence. So practical tips if a tribunal asks for these presentations, or if you're considering whether or not they may be suitable for your case. First of all, ensure there is clarity before the start of the evidentiary hearing as to, firstly, how long each expert will have for their presentation. Secondly, whether the experts will be allowed to produce slides. Thirdly, what will be the permitted content and scope of the presentation. And lastly, anything else which may be specific or relevant to your case. Before going down this route, consider your expert's overall presentation skills. It might be that your particular expert's presentation skills might not actually be suited to this type of process. Also, how much assistance has your expert had in producing their report? It's absolutely vital that any expert who provides a presentation of this nature is on top of all of the detail. If they are not, this may become more apparent when delivering a presentation in this more informal type of environment. So bottom line is, check that your expert is comfortable with this approach before agreeing to go down that route. It might be that in these times again of virtual hearings, we may see more tribunals wanting this form of presentation before the more traditional style of common law cross-examination. Now I'd like to move on to the topic of witness conferencing, and you'll see on the slide that we have a picture of a hot tub. Now, 10 years ago, everyone was talking about hot tubbing. Although some people are still talking about experts getting into the tub, for my part, I think the term witness conferencing is a much better phrase to use. Not only does it give a better visual image, but it also sets a better tone for what can, in my view, be a very useful and serious tool at any arbitration hearing. In an international arbitration survey carried out in 2012, it was revealed that 62% of respondents believe that witness conferencing should take place more often due to the many benefits that you can gain from this process. And again, this certainly is my personal experience. It can be a very effective tool at a hearing. For anyone who is listening who is not familiar with what witness conferencing actually is, very briefly, it is a process by which evidence is taken from experts of a similar discipline simultaneously. Each expert engages with the tribunal and each other in a forum-like discussion. As with the expert presentations that I discussed just a moment ago, there are no standard guidelines to facilitate witness conferencing. However, again, the institutional rules generally have sufficient flexibility to allow the process. Indeed, the option of witness conferencing is clearly on the menu where the IBA rules are in play. And Article 8.3 of the rules provides that the arbitral tribunal, upon request of a party or of its own motion, may vary this order of proceeding, including the arrangement of testimony by particular issues or in such a manner that witnesses be questioned at the same time and in confrontation with each other, which the rules expressly refer to as witness conferencing. Now, there are different ways in which witness conferencing can take place. So, for example, the witness conferencing may be a counsel-led approach. Now, in this approach, it's a mix of traditional common law style cross-examination combined with a panel discussion. And the tribunal will intervene after the counsel have asked their questions. However, there may be a more tribunal-led approach to witness conferencing, and here the tribunal acts as a chair and leads the discussion between the experts, asking them questions and then comparing the answers that they give against each other. Here, the procedure is obviously led by the tribunal, and then the counsel will have an opportunity to ask questions at the end of each particular topic. Now, moving on to look at some of the perceived pros and cons of witness conferencing. So, firstly, taking the pros. Witness conferencing can be particularly effective in arbitrations with complex technical and factual issues, and where parties rely on multiple experts of different disciplines. It can certainly help the tribunal in cutting through the issues and seeing what the differences really are between the parties. In my experience, the experts are also often more relaxed when they give their evidence in this forum. And it means that the responses that they give are actually more helpful to the tribunal than in the more combative style of traditional common law cross-examination. It also means that experts are less likely to present a strongly partisan view in the presence of their peers, who are able to challenge those opinions directly. And as a result, experts are likely to be on the same page and adopt similar assumptions. Now, this can disarm an expert who may appear to be a hired gun, and it can really improve the efficiency of the hearing and assist the tribunal in getting to the heart of the issues. If you have a particularly strong expert, as a matter of tactics, you may choose to deploy them in this forum to draw out the weaknesses in the evidence of the other side. However, what are the cons? Well, unsurprisingly, there is a flip side to this coin. And it may be that it is your expert that is more willing to make concessions or to agree with the other side's expert, where perhaps they ought not to. In some cases, the experts may end up in a general discussion with the arbitrator about the case. And whilst this may be very helpful for the arbitrator, it can leave parties and their legal team with that sinking feeling about where their expert's oral evidence may end up. So, practical tips. Because of the potential risks with witness conferencing, you need to again think carefully before you go down that route. Ask yourself, does your expert have the right qualities to stand up to this more informal nature of questioning? Will your expert concede points unnecessarily? Can your expert stay very closely to the points which are being put? If by the time you get to your hearing there is a risk that you think your expert may be a bit of a loose cannon, your expert may be too risky. It may be too risky for your expert to engage in this type of witness conferencing. But even if you think that perhaps your expert may be a bit of a loose cannon, there will be ways that you could keep them on target during the witness conferencing session. And one of the ways that you may do this is by using a list of issues based on the expert joint statement. In fact, I have seen witness conferencing used very effectively with a list of issues derived from the joint statement. In that particular instance, the joint statement identified the areas which were agreed and not agreed between the experts. And the not agreed areas then formed the list of issues and agenda for the witness conferencing. This enabled the tribunal to move through the outstanding issues between the experts efficiently and quickly, and to seek each expert's view on the outstanding issues. This made the questioning process very focused. And it also meant that the tribunal had each expert's views in respect of the matters that were truly an issue between the parties. However, a note of caution: as we all know, joint statements are often agreed late in the day and sometimes in a rush. So make sure that the joint statement will provide a sufficiently broad agenda for the witness conferencing if you choose to use it in that way. So, lastly, if considering witness conferencing at your arbitration hearing, agree how the time will be allocated between the parties, and make sure you give thought to the agenda for the session. There may be other ways that you could agree an agenda, but in my view, a sensible starting point is to use the not agreed issues identified in the expert joint statement. You will also, in my view, it would be very sensible for these matters to be agreed at any pre-hearing conference so that there are no surprises when you get to the final hearing. Many thanks. I'll now hand you over to Sean.
Thank you. Finally, I'm going to say some brief words about enforcement before we move on to the Q&A. I see we have a number of questions which have come in during the talk. Enforcement. Energy arbitrations raise particular problems for enforcement. Very often in a large-scale field, you will require ongoing cooperation from the national oil company. That will create issues, obviously, if you seek to enforce. Similarly, the awards can often be very large. There is one case which is notorious at present, where an award of several billion is putting the host nation in particular difficulty. Next consideration: do you have a large amount of kit in the country? If so, how will it be impacted? In mining projects, you have a lot of material in country, similarly in energy projects, and you can see cases where that infrastructure is seized or otherwise placed under other person's control. In other words, enforcement may trigger resource nationalism. Resource nationalism is back. We've seen an increase in the last year in Africa. There are certain countries which are particularly notorious at present for it. It's coming in both transparent and less transparent forms, increased tax burden, increased licensing burden, then of course straightforward appropriation. So you have to have that in mind. Is there a time and value of money in extraction? Again, with mines of all types and energy projects, you're dealing with a resource which you are extracting is therefore getting smaller. If you have a long-running arbitration and the resource is still being extracted, then the share of the size of the pie which you're fighting over decreases over time. How are you going to get around that? Is that an issue? Are you better coming to a deal? The sheer amount of the award can bankrupt the host country. And then again, you can have the issue that recovery against local partners can be difficult. We all know of certain jurisdictions which are particularly notorious for this, and this again can raise issues, practical issues in terms of enforcement. If we could turn to the next slide, where I'll talk about the legal problems. Sovereign immunity. Sooner or later, if you've got a big enough project, the host nation is going to be involved. Has the state waived immunity for both the purposes of the arbitration and enforcement? These are separate under some systems, e.g. section 13.3 of the State Immunity Act. So very often you can have a situation where the host nation will waive immunity for the arbitration, but won't have waived for enforcement. Are the assets in fact state assets? If so, you can only enforce if they are used for a commercial purpose generally. In England and Wales, that's the case, or that transaction. This is obviously relevant if you're looking at, say, arresting an aircraft to enforce, if you're invoking that particular nuclear option. Are they used for diplomatic purposes? So you can't just nip along and seize someone's embassy, because that is used for diplomatic purposes. It's not a commercial asset as well. Anyway, diplomatic immunity may apply. If we could move to the next slide. More particular issues. Has the arbitration intruded into public policy? We all know that it's a standard principle against enforcement if public policy of that particular nation has been breached. It can be trickier than a pure, if you like, highline legality point, because you can see arbitrations where there's a dispute over tariff setting. I'm thinking about power to mines or water. And so that may intrude on public policy, particularly where you have, for example, a long-running drought, where nations will want to control water flows within their borders, and then, of course, across a border. Have you gone into taxation and rent extraction issues? Again, I've seen this in arbitrations where there is a very heavy public principle in play, which means that enforcement could be difficult. Are there licensing issues? Are you actually trying to bypass the licensing regime? Again, public policy is in play. Back to resource nationalism, simple refusal to recognise the award. I've had that very recently, where I was assured that there was no way at all that the host nation would allow this award to be enforced. That caused my eyebrows to rise slightly, in that how my client knew that, but obviously that is out there and that is a risk. And then if you are in that sort of position and/or you're going to be retaliated against, is there a bilateral investment treaty or a free trade agreement in play? Always think about that. You've obviously got to be careful because it may not give you the protection that you want. If we can move on, please. Thank you very much. We move to questions and answers. I'll start with the first question, which is pleadings or memorials. Rachel, over to you on that one.
Right, so pleadings or memorials. In the context of international arbitration, sometimes we see parties and tribunals wanting very detailed memorials. And this may, for example, result in a party serving its statements of case, its expert reports, and its witness statements all at the same time. The statements of case are also often very, very lengthy, many hundreds of pages, and cross-referenced to the expert reports and also the witness evidence. Now, if you have an arbitration where you're dealing with this type of memorial style pleadings, it's often a huge task and a huge undertaking. Now, in my experience, in order to pull it off and for them to be effective, you need very military style operation in order to bring everything together in time so that it hangs together properly. There are advantages and disadvantages of using memorials rather than the pleading style. I suppose one advantage is everything is laid out at the same time and you can see everything in context. But one of the big disadvantages, I think, are that sometimes they can very much take on a life of their own and can sometimes become slightly unwieldy and very expensive. So my view is that perhaps somewhere in the something in the middle of what would be more traditional style English pleadings and very detailed memorials is perhaps the way to go for international arbitration.
John, any views?
Disappointingly, I largely agree with that. Something in the middle. I think true English-style pleadings can be useful if the lawyers and the tribunal are all from Commonwealth backgrounds and know how to use them. They can be useful tools for organising the proceedings. For lawyers from different backgrounds, I think they can find English-style pleadings a bit bemusing. And to clients, they can come off as a bit of a damp squib because there isn't much advocacy there. I've known clients who are handed an English-style pleading and the reaction was a bit, well, is that it? But I agree with Rachel that memorials can become very wordy. It's sometimes unclear whether a party's amending its case between iterations of memorials or whether it's just phrasing its case differently. So I think an ideal is to have a relatively a relatively brief document that operates as a standalone. An arbitrator could read on his iPad on a plane without reference to other documents or other pleadings. I think that represents a middle ground that is user-friendly in an international context. What about you, Sean?
I don't get too hung up on the label of pleadings versus memorials. What is my pet dislike? Well, I have two pet dislikes about memorial style as it is done by some practitioners. A, prolixity, and B, iteration stroke confusing cases. I agree with John and I agree with Rachel that you shouldn't really get hung up on the label. What the focus is precision and ensuring that the case is clearly enunciated so the arbitrator or arbitrators know what they're dealing with. Next question. The current debate over transparency versus confidentiality. Where do you stand on that? Okay, I'll kick off on this one. I am not sure that automatic confidentiality is much of an advantage in arbitration, because when you get into large arbitrations with host nation, there are inevitably questions of public policy. We saw this over the angst over TPIP, over whether all these big arbitrations were going to be confidential, and that would meant that public policy decisions were being decided in private. Again, transparency can benefit both sides because the government may need to be transparent and the private entity may need to be transparent about what they're doing. We see awards published in treaty arbitrations, and that doesn't seem to be a problem. Finally, and not entirely facetiously, if there is more transparency, parties are less inclined to take bad points. John, any views?
I agree with you that particularly in investment arbitration, there's not a strong case for confidentiality when awards can run into tens of billions and touch on issues of public policy. In commercial arbitration, I have more sympathy to it. Many corporate entities say they like confidentiality in the process, and so I think it should be protected to that extent. I think there can be increased transparency in arbitral decision making. So the ICC publishes procedural decisions and is starting to publish awards with party names redacted. And I think that helps shed some light on the process and is a good thing. Rachel?
I'm going to keep my responses fairly brief, but my view is that many private commercial organisations and also indeed sometimes governmental organisations still very much find confidentiality to be a very important part of arbitration proceedings. So I imagine that many of them will not be keen to give it up.
Okay, it's 10:58, so I think we've got time for one more question, which I will pick more or less at random. Do you think the often international nature of arbitration lends itself to adapting to remote hearings in the COVID climate? And I'll start with Rachel.
My view on that is yes. I actually think in many ways international arbitration has almost been preparing to work in this way for the last 5 years or so, and often in international arbitration proceedings, people who are in the room will have some of the top technology at their hands so that they can deal with large bundles very efficiently and travel all around the world with them if they need to. So I actually think that this may be a good thing for international arbitration, allowing it to be much easier for parties to attend hearings without necessarily needing to travel to them.
John?
Yes, I mean, I largely agree with Rachel, though perhaps more regretfully. I'm keen to get back to the old normal rather than the new normal. And if international arbitrators give up international travel, then the game's up, I think. Sean?
2 points, keeping it quick because it's 10:59. First, I think the COVID situation may help certain arbitral institutions which have become very bureaucratic, slow and expensive to up their game, because your remote hearings are inevitably shorter because they have to be, and it can mean therefore the whole process could be less expensive and less onerous for parties. The second point is I think it will impact on English style cross-examination. We are all used as advocates to have the witness there in the room to gauge their reactions. And if you talk to any advocate who's done remote cross-examination, they will tell you that in a crunchy case where credibility is at issue, remote hearings don't really work. I think we are now out of time. We've not answered every question, but I hope we've given a reasonable stab at most of them. Thank you very much, everyone, for all your time. I think Marie will just fill in now with the practicalities of streaming, etc.
Yeah, so just to let everyone know, thank you again, as Sean said, for joining. We will be sharing the streaming of this recording on our website. It will be on our social media pages, and actually for any of you who've signed up, you'll receive that as well as the slides as a follow-up email today. So thanks again, and bye.